Are you my case timekeeper?
What to be? I haven't done this in a while, so.
Okay, when in doubt, give each of us more time. There's nobody behind us. 5 to open, 10 to vote, and he gets 15. And if they give him more time, I'm all for it. 5, 10, 5, 10. Even though 5, 15, 10 for my vote. Yeah, if you give me 20 and him 10, it'll be very unhappy. And sure, if you pull a gun and shoot me, if I go over my time, if it's just a taser and not bullets.
Well, you didn't do that.
Let you take your ass.
How long have you been doing this?
It's been a long time. That's the matter. All rise. Hearing, hearing. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution is on the court.
Good afternoon, please be seated. Welcome to the First Court of Appeals. We have one case on the docket this morning. It is case number 01-16-00-584CV. Zoandy v. Hogan. Will counsel please make their announcements?
Harry Herzog and Lauren Andre for Mrs. Solani. You were close.
It was close. Thank you.
Tim Hicks for David Haggard.
Great. Each side will have 15 minutes for argument today. Does appellant wish to have any time for a rebuttal?
That would be me.
Yep.
And I have 5 minutes opening, 10 minutes for rebuttal. But to keep time correctly, you have to roll into good afternoon.
Good afternoon. There you go. Okay. Very good. We're ready to proceed. Here, counsel for appellant, Mr. Herzog. And let me start with a question at the very outset here. I'm going to do that because we've read the briefs and the record. We're familiar with the facts of the case, so let's just dive into the legal issues. And here's my question. In the jury charge, the liability questions for the 13 statements at issue are granulated. The damage questions are broad form. The 13 liability findings for questions 2, 7, and 9 flow into 4 general damage blanks. So let's say we agree with you that one or more of the 13 statements are not actionable. How do we fashion relief in this case, since we don't know, based on the jury charge and the verdict, whether the jury awarded any damages for any particular statement?
5 Texas Supreme Court cases in the last 20 years help you answer that question, but then this charge gives you a little judo flip at the end. So it's a Texas two-step for you. First, absolutely under the Castile analysis, there has to be a clear finding of liability that survives appellate scrutiny. So in most of these instances, everything except the failure to publish the police report, it would be a reverse and remand. Now the twist is the jury damages are broken into questions 10A and 10B. And on one of my arguments, I think, it would only affect question 10A, and therefore there's a question in my mind, which I have not answered, despite many a brain cramp, as to exactly the correct thing to do with regard to the jury damages in 10B if they survive all my other challenges. So.
Well, let's just assume, because I think you're right, it's like a map, right? What stays and what goes away. If there's some combination of statements that remain as to Part A or to Part B, because the broad form damage question was submitted without objection, can we even review? Aren't we required to affirm on damages because that issue was not preserved during the charge conference and the broad form submission on questions 10A and B was submitted by agreement of the parties?
I hope the answer is no. I understand your question. So here would be my answer.
Well, it's a real concern, so I really want both parties to really address this question.
It's a very real concern. It was a very real concern in drafting the charge. And so I'm not trying to make light of it.
Sure.
I'm just saying, I believe when you have question 10A, which has
So leave 9.
8
Or
subparts.
Okay. And we
8
have it here in front of us.
It's page 17.
Yeah, we got
We
it.
have
Okay,
it.
all right. It has 8 subparts in question 10A, and then you get 4 answer blanks. If any one of those subparts is taken out,
Correct.
I believe under the Castile analysis, it's reversed and remanded for new trial. It's not rendered.
But the question is, did you have to preserve that at the trial court in order for us to engage in that analysis?
That was
And
my
was it
question.
preserved?
Did you make a Castile objection to the jury charge?
I'd have to go back and reread it to give you a perfect answer.
Okay.
This is 5 years ago to the day we gave oral argument in this court. 7 years ago, I tried this case. I'm not going to tell you that I perfectly remember every objection I made to the charge. I'm not going to tell you I did or did not make a Castile objection to the charge.
Well, let's just ask you this question. If there was no Castile objection made to the charge, because I'm not going to hold you to what happened 12 years ago or 7 years ago. If there was no objection, Castile objection made to the charge, has that issue, are we required to affirm as to damages if any of the statements remain as to Part A or Part B?
The best answer I can give you right now, having not thought of that question until y'all asked it this afternoon, is I think we made it very clear, and the Supreme Court has made it very clear, that you can't do broad form on liability in defamation, and therefore we made no objections to the granulated questions on liability. The judge switched to broad form on damages, thinking he was doing the correct thing. And it was my belief that if we defeat questions 1 through 9 in a Castile analysis, we defeat the damage question on a Castile analysis.
Okay.
That's the best answer I can give you right now without going back and looking at my objections to the charge. And I'm glad you started with a question. I knew when you took it from submission to oral argument you had questions, so I'll save 10 minutes for the vote.
Thank you, counsel. We appreciate your argument. Counsel for appellate, ready to hear from you. Max, if we're going to ask you, I'm going to ask you the same question that I asked counsel for appellant at the outset. Given that the jury charge has the 13 statements submitted in a granulated format, they flow into the damage question 10A, has 4 general blanks for general damages. Assuming we agree with the appellant that one or more of the statements, one or more of the 13 statements are not actionable, how would we fashion relief in this case if we don't know, or if we're unable to determine, ascertain from the record, the jury charge in particular, whether the jury awarded any damages for any particular statement? So how would we fashion that relief?
You'd have to affirm it because, first of all, it was not objected to in this case. I actually highlighted and have the jury charge part here. And I was looking for all the objections.
Do you have record citations for that? Okay.
Volume 10 starts at page 10, and then it ends at page 31. That's the entire colloquy regarding the jury charge objections, and there were no objections at all. As a matter of fact, he said there is no objection after they covered all the miscellaneous objections that there were. And so, if you don't object to a broad form jury questions on damages, it is waived because there's also a presumption that broad form is generally the way to go. Of course, everyone knows about Castile and how you should granulate it, but where you specifically don't object to it, it's invited error, and it's waived, and it's just can't be raised in appeal.
But do you agree that if that were the case, that we would still have to review the sufficiency of the evidence to see if there's enough evidence of damages? In other words, there's proximate causation and there's actual evidence that supports the jury's award of damages nonetheless.
Yeah, exactly, because you just can't, because given the jury charge, as it's pretty clear from the questions, you realize that it could go under all or some of the different questions that they found a yes to. And so no, you couldn't reverse under that because it would just be speculating as to what happened. But also worse here, the way that the defamation case was presented was purely under truth. A very harsh truth defense was pushed through them from the very beginning. You can look at the opening arguments and have basically, clearly, textually, he gets up and just looks at the jury straight in the eyes and tells them that he's going to prove that my client's a pervert, a child molester, and all this horrible stuff. And they push truth from the very get-go. And also the way that the facts developed, this whole, this large blunderbuss of slander and defamation that was pitched, it was all combined together and it's all interrelated. And so just looking at from the way that they presented the case and the way that the evidence of all the defamation went down, it was all so interrelated anyway that it's all hooked together. And so you know the damages are all tied into all of the same jury.
Well, let me ask you this question. Maybe I'm missing something, and we're trying to decide why were the damage questions split into Part A and Part B? Is there a significance that I'm missing as to why the statements were categorized into 8 under Part A, 10A, and then 5 under 10B?
I actually don't know why they did that.
Okay.
To me, there were a lot of strange things about the jury charge. And so it's not clear from the record why this was done.
Okay.
And I can't figure out logically just looking at it why it
Okay,
was
so
done.
jumping then to the damages here, there's 2 categories of damages, reputational damage and mental anguish damage. I want to ask you specifically if you can point us to the specific evidence that supports the awards for reputational damage, both under Part A and Part B of Question 10.
Yeah, it was the testimony of my client. There's 2 sections. There's Volume 7, which starts at page 184 and ends at page 196, and then Volume 8, which begins at 78 and ends at page 92.
And that's still Mr. Hogan's testimony.
Yeah, it's all Mr. Hogan's testimony. And that's very cogent testimony where my client was describing his history with the church. His father created the church. His entire life revolves around the church.
So there's a lot of testimony as to the mental anguish that he claims he suffered as a result of it. I want to focus more on the reputational damage. Was there any evidence that was admitted, and can you point us to that evidence where somebody testified that their opinion of Mr. Hogan changed based on the specific statements that were listed in the jury charge, the 13 statements?
Right. I believe that the evidence that supports that is the same sections that I cited to you because of his loss of his flock. And it was all, his parishioners, because they kept data on how many parishioners they have.
You said the same section cited in the brief, or the same section cited where?
It's what I just quoted, the volume.
How do we know the reason the parishioners left were based on these 13 statements, is my question. How do we know that his reputation suffered, other than the fact that some of these are defamatory per se statements? How do we know, what evidence is there that his reputation actually suffered as a direct consequence of these damages, of these statements, I'm sorry?
Because of Mr. Hogan's testimony describing how it is that his parishioners left in large numbers. And he described that with respect to timing as to when his publications came out also.
How do we know that wasn't just as equally plausible based on a lot of other statements in the blog that were not being challenged as defamatory?
Because you have to accept the evidence in the light most favorable to the verdict. And the way Mr. Hogan described how and when the people left was in the context of when the publications came out. So there's at least a reasonable inference that it was caused from that. and nothing else. Plus, there wasn't anything else that was developed in the trial that would indicate why people would leave, other than the timing of the way all this defamatory information came down.
For question one, and specifically as to publication, who were the oral statements in the police report published to? There's an allegation by Ms. Solani that those statements, the first two statements in the police report were not published, and that question was specifically asked of the jury. To whom were those statements published?
She stated in her blogs that there was an ongoing investigation, and it had already been closed at that time. She gave the case number and gave data that would allow the readers of the blog to find the actual offense report.
Okay.
So.
And as to the third statement in the police report, there was no publication question in jury question number 5. So I presume that it's undisputed that third statement in the police report was published.
Yeah, right. And also, she actually took the position at trial that she did all of these things. And that was their classic defamation defense was truth. And they even argue now in their brief regarding the mitigation damages charge that my client didn't mitigate because it's kind of a strange argument, but basically my client didn't mitigate because he did all of these things. So they're still taking that position in their brief. That's in their reply brief.
I have a question on the publication as far as the police report goes, and this might be just my own confusion. There didn't seem to be any necessary discussion in the briefs about this, but is her act of reporting that to the police considered publication? Or does it have to be that it's worded differently in this case, but I've just been a little confused about what part was the publication? Was it her? Do you see what I'm asking?
Yeah.
And I think at trial, or maybe it's in your briefing, you mentioned, that she made the statements and she didn't refute that she made those statements to police, and that was publication. Is that the law on publication with regards to a police report? I mean, there's a qualified privilege to be able to report to police. I'm just trying to figure out
That's
what.
under the statute.
Okay.
It's not a qualified privilege under common law.
Okay.
Defamation. So, okay.
Okay, that helps right there.
Okay, so the first quote is stated on what you just asked. Okay, so it's the defendant is liable if her actions create an unreasonable risk that the statement will be communicated to other people by third parties. So republication of the offense,
Right.
Police report and all that. And so here you fall squarely under that law, which is, by the way, it's Wheeler versus Methodist Hospital. That's 95 Southwest 3rd, 628, spot site 639, 640, First Court of Appeals. So if the defendant creates an unreasonable risk that the statement will be communicated to other people by third parties, then you have, you answer your question. And so here she put the very data about the offense that she's put all the really inflammatory information in there about what he had done, how there's an ongoing investigation, there was not an ongoing investigation, and gave specifics how to go find that. And so that gives rise to this unreasonable risk of republication that the first court has already spoken on. And by the way, that's not just first court law, that's classic defamation law that goes way back into our treatises. So I think that answers the question
That
you're
helps.
asking me there.
Yeah, that helped me. Thank you.
Okay, there's a few other things here. I don't know if opinion is an issue for y'all or not. But the Texas Supreme Court, in their opinion in this case, said that issue was open. But actually, if you go back and read the previous opinion from this court in this case, that was already answered on page 231 of the original opinion. And basically, what was saying in y'all's opinion is that these statements were not opinion because they're just pure factual statements.
Mr. Goodman, I do have a question on that. You pointed out, you started off by saying the truth was a defense in this case. And in fact, the jury
That
was
was their
asked,
only defense.
Right, their only defense, correct. And the jury was in fact asked that very question. Were these statements false? Is there some, is there some inconsistency with advancing, in your view, and I'll ask Mr. Herzog the same question, but is there some inconsistency in advancing that these statements were an opinion while at the same time asserting a truth defense? That the statements were in fact truthful?
I think it's completely, absolutely inconsistent. If you get up there and say that's my opinion, then you're essentially saying my opinions are not necessarily true. They're just my opinions because it's not knowledge, it's just rank opinion. Okay, I do have to correct you on one thing.
Sure, please do.
The jury charge, complicated jury charge, it's hard to remember it all, but a big portion of the jury charge assumed that the statements were true. And so you didn't actually, I could be wrong on that, but there's a strange...
I thought that they were asked specifically as to each statement whether the statements were false.
Let me, without getting too bogged down in this, there was some strangeness about the predicate built in within the questions regarding what you're saying, and I discussed that in the brief. But the point is that a large amount of that was irrelevant for charge purposes because they had said, look, all this stuff's true, and therefore we're not liable.
I think we're on the same page. I understand what you're telling me.
But just from a write-up perspective, I think it would be useful to actually go look and see where that predicate, because that predicate is not in all the questions.
Right.
And so some of them need you need the actual finding on the predicate question of truth or not, or whether they were said. And so just from a write-up perspective.
Yeah, no, I did see that the only question as to whether the statements were made was in regard to the police report. So maybe I made the incorrect assumption that they had agreed that the other statements were in fact made, and there was only a question of fact as to whether the statements to the police officer had been made, because there was an allegation that the officer had reduced those statements incorrectly in her police report.
Yeah, definitely it requires some digging in the record to sort that mess out. But the larger point, very strong, and I think maybe I'm repeating myself in this, but very strong, very aggressive. Oh, he's a pedophile. We're going to prove it. He's some interest in, angry mama bear is going to tear up and all this stuff about my client. And the point being, aggressively, we did all this, but it's all true. And that was the whole tenor, which neutralizes a lot of arguable problems that could be on the jury charge, which they never argue about, by the way. And so, you can't reverse on that on appeal. So
there was a question about the application of the clergy privilege here, and that admission was improperly excluded on that basis. In your remaining time, do you want to
yes.
go into that?
Okay, so the page 9, or rather volume 9, page 88, the judge said, I'm going to say the privilege stands because he came looking for spiritual guidance. Okay, now, if you look at the rule of privilege, you go to really just about anybody that's a spiritual type, preacher type, and you go to them for spiritual guidance, it's covered. The first court is really one of the, there's very few cases on this, but the Wells Court has written one of the, the lead cases on it. It's Nichols versus Wittig. I don't know if you've seen it or not, but it's page, it's volume 832, Southwest 2nd, 681.
832 Southwest 2nd.
681.
Thank you.
And I did a recent search to see if any other cases have come out since then, and there's really nothing. That's the case on this whole, but it goes back into the actual language of Rule 505. And so here, if you read Reverend Burroughs, there's a written statement he made. That's Defense Exhibit number 7. Mm-hmm. If you just read that, it looks like he clearly has an axe to grind with my client's family, because they were all in his church together. But you can read through there and see that he's clearly saying that Mr. Hogan came to him for spiritual guidance.
Well, can I?
No, ask your question, please.
If we assume the waiver, we assume the privilege applies, was there a waiver here? Mr. Hogan did venture into some content of his conversations with Mr. Burroughs during his testimony. And there's also some evidence in the record that Mr. Hogan discussed the nature of his conversation, not just with Mr. Burroughs, but he talked to the nature of his conversation with Ms. Solani's parents, and with his own peers outside the context of a clergy membership? Did he waive privilege?
Not with anything with respect to the preacher.
Why
Because-
not?
Because the privilege is so broad that it covers everything that's said, and when you go for spiritual guidance, that's a place where you can come and just let it all out.
So you're saying there's no waiver that applies to this type of privilege?
Oh, no, not at all. If you look at.
And so you think, would Nichols inform us on that question?
Say that, I'm sorry?
Would Nichols, the case that you cited, inform us on that question?
I believe it would, because Nichols makes it very clear that this privilege is very broad, and it's designed to protect, when you go into the closure everything is privileged, because they're trying to, the underlying policy is to try to, really develop the safe space to go and get spiritual guidance from your preacher type.
Your time expired a little bit ago, unless there's other questions. I'll let you finish your answer.
Yes,
And then
okay.
we'll give you some extra time to make up for it, make it even.
And then the most important thing, really from a purely legal point of view on this, is that if the ruling is within the zone of reasonableness, it's the trial court's call. If I would rule differently, that the Court of Appeals can't reverse it. Plus, it doesn't show that there's a improper judgment. You got to show that the ruling created an improper judgment, and here that the same evidence was developed in a very big way by the defendant in this case. She went on and on about the exact same information, and then my guy fully rebutted it, and so there's just no showing of an improper judgment.
Thank you. We'll hear from appellant's counsel for rebuttal argument. I was going to ask you a quick question, the same question we asked your opposing counsel, the Justice Rivas Beloy asked. In terms of the damage questions, 10, why was it submitted Part A and Part B?
Because the other side wouldn't listen to me. And the judge did it their way.
Okay.
That's the totality of the reasoning. There's nothing in the record that'll help you.
Right.
If I can have about 2 minutes to answer all the questions that have been asked so far and then take new ones, I think I can be effective.
Sure.
First, the first question I was hit with was Castile. The best I can give you is in the record, volume 9, wasn't it? Volume 9 or was it volume 10? Volume 10, page 32. And I'm quoting starting at line 8. These are my objections. Stephanie Zawani, at the conclusion of the case, before the charge is read to the jury, moves the court to not submit these 4 proposed elements of damage 2 different ways they were submitted for the detailed reasons set forth in the 7-page typed brief provided as Defense Exhibit 101. Now, your next question is going to be, do I remember exactly what I put in that 7-page brief? And the answer is no.
Okay.
But I will refer you to that. If I made a super detailed Castile objection, that is where it will be.
Do you know what, is that brief in the record, or?
It's Defense Exhibit 101. It's supposed to be in the record. I got in a hand-to-hand fist fight with the clerk for over a year and a half to get the record.
We have it.
Okay, perfect.
We looked
Now,
at
the next thing I want to talk about is Mr. Burroughs. Mr. Burroughs' testimony at Volume 9, page 76. Volume 9, page 76. When we were discussing this issue, my understanding is that it wouldn't be about a spiritual nature. The exact opposite of what Mr. Hoodman just told you. I know what they wanted to argue. I know what they still argue. But it's not what happened.
But there are other places in the record. Sorry, I was going to say there's other places in the record where he did state that he believed it was about spiritual things. What was the wording? Not versus legal or something like that.
What he said with clarity repeatedly is it was administrative. It was, he's coming to me and he starts a certain way and then it says, is there more, is there more, is there more? And then Mr. Burroughs, this is undisputed, told Mr. Hogan, you have to take what you told me and tell it to 2 other people today. Today, you have to report this to your superiors in the church, which destroys this argument of confidentiality. And there is no dispute that Mr. Hogan went to those 2 people and reported to them that day, which
Let's
is a waiver.
assume that's the case. How did this lead to an improper judgment, considering that we've got
Because-
multiple other witnesses who seem to testify to the same, basically the same stuff?
I can answer that question easily.
Great.
Having tried over 120 cases, I know which witness wins and loses the case. They attacked the other witnesses, viciously, vociferously, aggressively attacked every other witness to whom Mr. Hogan made this admission. They could not attack Mr. Burroughs. They had no way to attack the man. He wrote an exhibit that you have in the Bill of Exceptions. I don't remember now, it's Exhibit 7 or 9. It's an appendix to...
Seven.
We have it.
We
It's
have it.
Exhibit 7.
It's
Yeah.
Exhibit 7.
Laying out in great detail what the man said to me. And so, the inability for them to cross-examine this man, this was by far the most disputed event in the trial. By
Okay,
far.
well, let me ask you a question. That specific statement that Mr. Burroughs made, I assume that you would have brought it to establish some sort of truth as to the nature of the statements that Ms. Solani made.
Absolutely.
What specific statements does Mr. Burroughs' testimony relate to of the
Pedophile.
13? Of the 13, can you identify which
Every time the word
specific one?
pedophile appears.
Well, it doesn't appear in every statement. So
That's
you're saying
correct.
Mr. Burroughs' statement would not have gone to all 13 of the statements?
It
It
would
would only
not.
have gone to some?
It would have gone to most. Would have gone to most.
Do we know specifically which ones? Are
If you want to look through the charge, I'll tell you. I'm happy to do that.
Here.
I've got the charge, here it is.
So do we.
How about I go through 10A and 10B?
That would be perfect.
Because they cover every statement.
Oh, here.
It would go to 10A, which is the going into the bathroom,
Okay.
peeping in, to the shower, to the air vent. It would go to 10F,
Right.
10H. You've been informed father is a pedophile. It would go to 10, those are all in 10A. Now we get to 10B, it would go to A, B, pedophile. C, last word, pedophile. D, pedophile father. E, problem with preteens. This is an instance where the man admitted going into the attic, seeing he could remove an attic vent fan and see into the bathroom, and going up into the attic to see a 14-year-old girl in his youth group at church because he wanted to see her take a shower. And instead, the other 14-year-old girl, his sister-in-law, his wife's younger sister, went into the bathroom and sat on the toilet. And he was like, "Oh, not what I wanted, bad deal." He confessed it repeatedly to many people. But the only one who could not be attacked is Mr. Burroughs.
Okay, so let me ask you a follow-up question. Obviously, the truth was a defense that was asserted at trial.
That's correct.
Why is that not inconsistent with the allegations now on appeal that these statements were an opinion?
Some were truth, some were opinion.
Well, I understand that, but we're going to have to go through all of these 13 statements and make some sort of
No, you don't.
heads
Four
or
of them
tails of
four of them you've already ruled on, and on the other 9, I mean, when she says, where did I just put it?
Well, let me ask you, so on a more basic level, if you're asserting that a statement is truth, can you also assert that it's an opinion? And the reason I go back to the argument on appeal, that the allegations that Mr. Hogan is a pedophile, I remember, let me make sure that I go back to my statement here. But the argument is that there are quote, foundational facts that support Ms. Solani's conclusion that Mr. Hogan was a pedophile. And then the brief goes on to illustrate the specific facts that establish that he is a pedophile. And that's in the quest to establish the truthfulness of those statements.
Okay.
I'm having a hard time then also concluding that those statements are an opinion as a matter of law.
That's because you're misunderstanding our position. So here's what I will say. There are many, many, many things that Mrs. Zawani said about the man that she said are true. And there are also some things she said that we believe were opinions. And that's the easiest answer to your question. Now, in a global sense, And I believe it was Justice Countess that asked the question about how do you separate the damages. And here's what I will say. Your question missed a critical component that I want to add to it. Mr. Hogan admitted on the witness stand that there was a secret David. He admitted orally, testimonially, and in writing that he had a pornography problem, particularly voyeuristic porn. He had it on his church computer. He did 1 year of counseling. He was suspended from the ministry for a year for it. He admitted placing a spy camera to watch his best friend and wife have sex
You were able to argue all of that to the jury, right? The jury considered that argument and that evidence.
Yes.
Right. So,
But none of that proves pedophile. What proves pedophile, because his best friend is an adult. And I can't prove that he was looking at kiddie porn. All I can say is he admits he was voyeuristic in looking at porn. What proves pedophile is sneaking into the attic to look at a 14-year-old girl take a shower.
but that evidence was introduced at trial.
And highly contested. Pennzoil versus Texaco was tried for 5 months and decided by 3 witnesses and 1 piece of paper. American Airlines versus Continental was tried in Galveston for months with the best trial lawyers in America and decided by the last witness. This trial was decided when the judge excluded Mr. Burroughs. Without Mr. Burroughs, I had Mrs. Zawani, I had Mr. Hogan on the oath denying, on the stand, denying that he had said it to the people he admitted it to. I had Justin Trapp, who they attacked viciously, and I had Mr. Burroughs.
So, but I kind of have a similar question, which is, even if the additional, the addition of Burroughs' statement, whatever it is you're saying, could have come in. I mean, pedophilia doesn't that require like a diagnosis? I mean, you're saying all you needed was the clergy's statement to come in to make the statements about pedophilia.
I'm not going to call it a clergy
verifiable?
statement. I'm not going to call it a clergy statement. Here's what I'll say. I needed Mr. Burroughs to testify where he could not be contradicted, could not be attacked, that there's no way to attack the man, and there's nothing in the record that shows they could attack the man. I needed him to be able to say, this man intentionally went up into the attic to look at a naked 14-year-old girl. That meets the textbook dictionary definition of pedophilia. I don't need a psychiatrist to give the diagnosis. His ex-wife is entitled to say he's a pedophile because he wanted to look at my naked 14-year-old sister, or her naked friend.
Was there, I don't recall whether there was any objection made regarding waiver. I think you mentioned waiver in your brief, that if the clergy privilege did apply, the plaintiff waived it.
Sure.
But you didn't point us to, did you object? I didn't find that.
Here's what I was saying. He was told he had to report it. He was told it wasn't confidential. He went and reported the same day to 2 other people, and the essence
Within the
of,
church. You reported to 2 other people within the church.
well, not within the church where he worked, but within, for example, if you're a Baptist minister, you'd have to go to the Southern Baptist Convention. If you were a Catholic priest, you'd have to go to some bishop in some other city. In a hierarchy above his church, he had to report because he was already on suspension for a year.
Well, he went to the board of the church. Are you saying that communication to the board of the church would not qualify as clergy privilege?
I don't think it does, but that's not the one I'm talking about. I'm talking above that when he reported to, I remember one of the man's name is Don Wee, and I can't remember the other man's name. Wee is W-I-E.
Granbury.
Yes. Mm-hmm. Granbury.
Granbury, thank you.
But when I was referring to your brief, in your brief you don't talk about that part. You talk about how he waived it when Mr. Hogan testified at trial about some of the matters that he had discussed with his minister, which is actually something that kind of caught my eye when I was reading the record. But I didn't necessarily see that there was any objection made to that at trial. But if there was, I'd love to know where it came in.
Are you asking me if I objected?
Yeah, I mean, if he waived it, if Mr. Hogan waived the clergy privilege by testifying about the same matter at trial, how do we get to find that if it's not preserved? That might be a better way to ask the question.
Okay. Well, that argument, I believe, was presented by Yelena Kovacevic when she made the argument to the judge. I remember that Yelena made the legal arguments on that point at one point.
Okay.
I did as well.
Okay, because it's not, you mention it, but then you don't give any cite to where that, okay.
What about a response to Mr. Hootman's argument that you cannot waive the clergy privilege?
Well, first it has to exist.
Well,
And-
let's just assume that it
Secondly,
existed.
every privilege can be waived.
Well, I don't know that that's true. I mean, in the context of the clergy privilege, and I don't know what the answer is, which is why I'm asking you both for guidance.
Okay,
In the context of the clergy privilege and the purpose and the nature and the policy of what it's protecting, within the context of spiritual guidance, where can we look to that would tell us whether this can be waived and what the analysis that we have to look at to see if in fact there was waiver of this privilege?
The best answer I can give you off the top of my head is any privilege can always be waived. But let me take just a moment. The rule doesn't say, the rule doesn't answer the question. So I'm just going off what I learned in 1981.
Which makes sense. I mean, which is why I'm asking the question, right?
Okay.
I got a follow-up. If we agree with you that this was improperly excluded under the clergy privilege, that was error, how does that dovetail into where we started with Castile in terms of resulting in improper judgment?
Okay, first I will say, without hesitation, as I went through the charge and gave her all the lists that it applies to with pedophile, you can see the importance of this issue in the trial. Please do not forget, for years, Mrs. Zawani was sued for defamation for calling the man a pervert. 10 days before trial, they wisely dropped that claim. Very silently deleted it from the pleadings for a reason. Next, on Castile. The Castile case talks, Your Honor, about theories of liability. That is the language of Castile. That case was argued by my friend Alan Waldron.
Right.
I wish I could tell you I made the world's greatest objection on the damage part in the
Right,
charge.
so Castile then flows into Harris County.
It does.
Right.
Harris County versus
Right.
Smith. It
And
does.
that's damages, so
It
that's
does.
what-
It does. But I'm just going to tell you, when you have all these theories of liability mixed, you can't then just go throw damages out. I think that's adequately preserved in the totality of the record. I am not going to put my finger on volume 10, line 72,
Okay.
or page 72. Now,
I think we'll give you a couple more minutes
Okay.
here, or
If I
a
can
minute
get-
or so here to finish up, we gave Mr. Hootman some extra time.
if I can get it without another question, I can do it. I love questions, but I got to cover this. There were questions from you, Justice Reeves-Molloy, about evidence of reputational damage. Easy answer: none, zero. It is impossible to find a witness who testified to the reputational damage, and it is impossible to separate the reputational damage that the man did to himself with all of the acts he admitted, including sexual immorality that got him punched a second time and permanently defrocked in his religious order, from anybody who says, I read any one of these 13 statements. You can't find one piece of testimony of one witness who says, I read or heard any one of these 13 statements, and I therefore think less of the man.
Does it have to be that specific? The jury can't infer from the, other evidence from Hogan's own testimony, from his wife's testimony, from, it sounds like what you're saying is it has to be sort of like the specific, this is reputational testimony. I'm here to testify that I'm not being sarcastic, I'm just trying to figure out what our wiggle room is here.
There's a $1,350,000 in damages awarded for loss of reputation.
Mm-hmm.
So there better be something there.
The statements were pretty egregious. If there's sufficient evidence that the statements were false, if the jury's finding is correct, I mean, the statements were pretty egregious.
If you call someone a pedophile and you can't prove it, it's egregious. I agree.
And vice versa. If you call someone a pedophile and the jury found that was, oh, yes, they were false, that's pretty egregious.
I agree. I don't know, it's 1.3 million, but it's egregious. I wouldn't want it done to me.
Well, how do we evaluate the number?
Well, I gave you...
There's no analysis in the brief that guides us through a remedy.
I gave you in the reply brief, in Appendix 9, Appendix 8, I gave factual cites for all of the improprieties. Appendix 9, I gave you just a list chronologically of key middle language cases. And in Appendix 10, I gave you awards, appellate scrutiny awards, I believe, in every one of those cases. Way less, 20,000, 25,000, 50,000 in most of these loss of reputation cases. There's nothing anywhere near what happened in this case. The other thing that I would add, there was a question about publication from both of you on publication, and I want to answer that correctly. First, there's an absolute ability to go to the police and report anything. The question is, did the police report get published? And what Mr. Hootman talked about had nothing to do with the police report. He talked about in the blogs an open investigation, but that is not the jury question. The jury question, which is 4 and 5, made and published, have to do with specific factual statements in the police report. And the evidence in this record is conclusive. The only two human beings that read this police report are Mr. Hogan, which obviously cannot damage him, and then he gave it to his, I don't remember if it was his fiancée at the time or his wife, because he later married her, but fiancée or wife. He was with her, he said, read this. And he gave it to her. There's no proof that Mrs. Wanning ever had a copy of it, nevertheless
Well,
published
is it new, let me ask you this, do you have to publish the physical police report or the oral statements made within the report?
Either
Because
one.
if those oral statements were republished later, would that qualify as a publication?
Yes, it would, but it never happened. And there's no evidence of her ever republishing these oral statements.
Including in the blog?
I don't believe she ever says in the blog, I made this. These quotes come, they've got it word for word in the charge.
Right.
And it only comes out of a written police report.
Do you have any further questions? Do you have any further questions?
No.
Just so we can even it up, we're gonna,
Yeah.
your time has expired. I don't think you're answering another, I think you answered her question.
I had actually covered everything I wanted to say.
Good. Well, thank you very
There's
much,
a lot
both of
to
you,
cover.
for
Thank
your
you so
arguments.
much.
We appreciate your arguments. They're very valuable to the court. With that, the case is submitted, and we are adjourned.
All rise.